The purpose of this morning's engagement is to conduct detailed scrutiny of the International Protection Family Reunification Amendment Bill 2017, a Seanad bill. The bill is sponsored by independent senators Colette Kelleher, our own Senator Frances Black, Senator Lynn Rowan, Senator Alice Mary Higgins, Senator Grace O'Sullivan and Senator John Dolan. We are joined this morning by Senator Kelleher, who will present the bill on behalf of the co-sponsors. We are also joined from the Irish Refugee Council by Mr Nick Henderson, the Chief Executive Officer, and Ms Rosemary Hennigan, the Policy Officer, and you're both very welcome here this morning. And representing NASC, not for the first time before us, and very welcome back, I'd like to extend a welcome to Fiona Finn, Chief Executive Officer of the Irish Immigration Support Centre, and Ms Fiona Hurley, the Legal Services Manager. So you're all very welcome, and I will shortly invite you to make your opening statements in the order in which I've just introduced you. But first, I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him, her or it identifiable. And members should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. Before inviting Senator Kelleher to make her opening statement, could I just remind witnesses and guests in the visitors' gallery to please switch off your mobile phones, have them on silent, because they impact with the recording equipment. So, Senator Kelleher, I'd like you now to make your opening statement, please.
Thank you very much, and thank you very much, Caoimhghín and the members of the committee for making space for giving detailed scrutiny to this bill, and obviously my fellow co-sponsor at the other side of the table, Senator Francis, for being such a supportive person, and the fellow members of the Civil Engagement Group. I suppose firstly it is worth saying that there is much common ground around the importance of family reunification, and where we differ with the government, it's more about the means rather than the end of it. So I think that's really important to say. And I want to recognise the actions of the Irish Government and the Department of Justice and Equality in support of refugees and their families, including the introduction of the temporary IHAP scheme. And I believe that we are united with the Minister that, that the end that we wish to achieve is very, very similar. But I think our means are different, and that's what we want to talk about today. I want to recognise the work of NASC, a wonderful organisation that it's great to have in Cork and doing such great work, the Irish Refugee Council and Oxfam Ireland, and indeed big thanks to Dr Roisin Hines, who's here in the gallery today, and all of the support that she's given on this. I want to thank the people who've shared their stories with us, people directly affected by the law. And I think the statement by Izzadeen Al-Kharraja and outlining the struggles that he's experiencing to reunite with his mother is just but one story, but an important one to remember, that there are human beings at the heart of all of this. And I think it's those kind of stories and the numbers of those stories that have really driven us to keep going, even in the face of government opposition, but huge political support in the Seanad and in the Dáil for the bill that you're scrutinising today. And I suppose it's really important because the scale of the human catastrophe that is unfolding around the world is unprecedented. The UN Refugee Agency has identified that by the end of 2017, more than 68.5 million people were forced to flee, 25.4 million of whom crossed borders in the search of safety. So the scale of the catastrophe that's upon us is huge, and therefore the scale of the response in Ireland and elsewhere has to be commensurate with that scale. And when we hear that the government is saying that we are doing a lot, there is no doubt that it is, but it has to be commensurate with the scale of the catastrophe that's unfolding. 5.6 million people seeking safety in Turkey. In South Sudan, there are 2 million internally displaced people. Hundreds of pregnant women, unaccompanied children and survivors of torture are being abandoned in refugee camps in the Greek islands. It's kind of unimaginable what that must be like for those people there. 2,275 people died or went missing in the Mediterranean, an average of 6 deaths per day. Again, it's also worth remembering that approximately 84% of displaced people live in low-income countries, where some of the poorest communities in the world are providing refuge. I was in Beirut when my son lived there, and there's 1 million people have come from Syria into Lebanon, and it's the size of Munster. So we need to measure our response in relation to the scale of the problem and what other very poor countries often are doing in the face of this catastrophe. A common thread that unites the experiences of all refugees is family separation. In the desperate search for safety, families can become separated and scattered, forced to follow different routes as they flee. And when a person reaches safety, finding and reuniting with their loved ones is often the #1 priority. Surely each and every one of us who has families can understand that. The Council of Europe Commissioner for Human Rights has identified family reunification refugees as a pressing human rights issue. You can imagine the extreme anxiety of refugees. How can you possibly settle? How can you possibly begin knowing that people that you love are in danger and under threat? And it has a real impact. The lack of family reunification has a real impact on people's ability to get on with their lives. My studies in family therapy reaffirms what I expect we all know to be true: the centrality of family in people's well-being and the ability to live well in the world. And that is what this family reunification bill is all about, to put that on a firmer footing so that people can have families by their side. This is a modest proposal. When this bill was being debated in the Dáil, I was criticised for it being too modest, I think, by Clare Daly, who moved it in the Dáil, and she was right in many ways. I would have liked the bill to go further. But it is an important one and an important piece of legislation, putting the right to apply to reunite with dependent families on a statutory basis, to revert to the definition of family that existed under the Refugee Act for almost 20 years, gives applicants a more realistic time frame for people to apply, and legislation calls for the bill to come into force in a timely fashion within 3 months following the date of legislative approval. There is substantial political support for this bill. It enjoyed substantial majorities in the Seanad and in the Dáil. And the small changes represented in this bill are necessary because of the restrictions introduced in the International Protection Act. Mean that refugees or persons with subsidiary protection currently have a statutory right to apply to reunite with a very restricted category of family members, and the 12-month time limit is posing huge difficulties, and NASC and the Irish Refugee Council will elaborate on that. So when we think of our children, for instance, who would here believe that they are fully independent at 18? I have a 28-year-old daughter, and we're about to put her on our insurance. My son is studying. We're still helping him out. Do we know of parents who financially rely on their adult children? Each and every one of us will know people. Our elder brothers and sisters who, through circumstances and chance, are the carers of their younger siblings. Relationships of dependency do not fit into the neat confines of the 2018 Act. Oireach supports our view that in their comprehensive analysis, Oireach describes the removal of the right to apply for family reunification for extended family members and the introduction of statutory time limit as retrogressive. So our bill would be in line with the recommendations that Oireach made in the report that they made last year. There was much debate, much made play by the Minister on that our bill would deny discretion. We do not believe so. Our bill sits well alongside discretionary programmes like IHAP. It doesn't in any way preclude them. But reliance on discretion alone creates uncertainty for refugees and their families. So that is why we make the proposals that we do in the bill. This is not an either-or situation. You can have rights and discretionary programmes. They are not counter to each other. Indeed, I would welcome broadening IHAP, but it has critical limitations. It is temporary, and, for example, many people who are in need fall outside of the 10 countries specified in that particular programme. A big concern, and it crept into the debate at later stages by the Minister, was the sense that any moves on migration was problematic per se. And I want to challenge arguments put forward in the course of the debate that migration and diversity are problematic per se and divisive. Specifically, I want to challenge the suggestion made by the Minister in the course of the debates on the bill that the arrival of more refugees in Ireland would provoke a political and social backlash similar to what we've witnessed in some European countries. My own lived experience challenges that. I was an immigrant in London for 17 years. I was a net contributor. I did sign on at the beginning, but I paid far more taxes in the long run in the 17 years that I was there. My children went to a state primary school in not very affluent Tottenham. 31 languages were spoken at the school where my children attended. They included my own, had parents with roots from all over the world. We were people escaping danger, poverty and mass unemployment in my case. And in fact, Fiona and I lived in a very similar part of London, as we discovered. I recall with real fondness my children's friends and schoolmates all learning and playing together. Crowland School was London Borough of Haringey at its best. Our home and school were in a constituency, although poor, voted overwhelmingly to remain. So this notion that diversity and migration automatically causes people to pull up the drawbridge is not the case in that situation. Government action in doing all that is possible in response to refugees and their families in a generous and welcoming way, as the Family Reunification Bill proposes, is the strong and moral thing to do. It can also be the popular thing to do. 70% of those surveyed by a report by Social Change agreed with the statement: if I was from another country and fleeing terrible circumstances, I would want Ireland to offer me protection. Only 7% of those surveyed disagreed. So we need to absolutely challenge and not follow the dog whistle that is often made in relation to conversations about refugees and migration. I was very surprised and disappointed by the Government's decision to deny a money message for the legislation, particularly as it came so early in the legislative process, October 2017, as I recall. I hope now that the Government have given this bill due consideration and are listening to the debate. The bill does not appropriate public funds. It does not compel the Government to make expenditure. It does not set up a new government agency or create a new body. I've heard the bill described as open-ended and that it will open the floodgates, but this is a fundamental misunderstanding of the legislation. The bill does not give people an automatic entitlement to bring dependent family members to Ireland. And as was pointed out to me, Standing Order 1791 says the bill cannot be initiated and take second stage if it appropriates revenue in the most meaningful sense of the word, significant charges. Standing Order 1792 then says it can't go forward to committee stage if it includes incidental expenses beyond this. Therefore, by letting the bill take second stage, the Bill's Office have already accepted that this bill does not involve the appropriation of revenue, Standing Orders 1791, and that the only cost issues here have to be incidental, such as admin. This tallies with the argument that an increased admin burden for the Justice Department is the real issue here. What the bill does is change regulations. It gives refugees and people with subsidiary protection a statutory right to apply to reunite with dependent families. Applicants must still comply with the rigorous requirements of the application. The Department of Justice still have control in accepting or rejecting the applications. This is a managed system. My colleagues in the Irish Refugee Council will be able to speak further on this. Any cost related to this bill would clearly be incidental. Should this bill require a money message, it is difficult to think of a piece of legislation that would not. The International Protection Bill is a family reunification bill is a timely, humane, modest piece of legislation which falls well within the resources of government that it has available to it. And I'm thankful to the members of both houses for their continued and overwhelming support for this legislation, and I am hopeful that we can resolve the money message issue as soon as possible and enact the urgent change that is so desperately needed for refugee families. Thank you very much for your hearing.
Well, thank you very much, Senator Kelleher, and appreciate very much the very strong opening statement, very detailed, and it's most welcome. I'd now like to invite Nick Henderson to present the opening statement on behalf of the Irish Refugee Council.
Thank you very much, and thanks to the committee for the opportunity to present. You have our written statement. I won't repeat it completely. I'm going to talk about two issues in particular. Firstly, to remind ourselves what the bill does and what the bill doesn't do, and then to speak to the money message and cost issue. In relation to what the bill does, as Senator Kelleher stated, we are submitting that this is a modest law, a modest amendment, and in effect it does three things. It broadens the definition of family from child and spouse to include child, spouse and dependent relatives. It takes us back to a definition that was existing in Irish law for over a decade. It creates an internal review mechanism. It doesn't create a new body, it creates an internal review mechanism to the minister. And it removes the 12-month time limit. And the importance of the 12-month time limit is that, in our experience, refugees will struggle to prepare a family reunification application within 12 months of granting of refugee status. They have to prepare themselves to transition out of direct provision, and they may indeed have difficulty in identifying and finding their family member in the country that they fled from. With the greatest of respect to Minister Stanton, we submit that he arguably overstated the power of the law in the Dáil when he spoke. It does not create the right of family reunification. It creates the right to apply for family reunification. And indeed, that application could be refused or it could be accepted, and that application will turn on whether the evidence submitted meets and establishes whether there was dependency between the refugee in Ireland and the family member outside of Ireland. The bill does not remove existing provisions that allows the minister to refuse an application. The minister can still refuse an application on the grounds of national security, of public policy, and indeed whether the applicant has been excluded from the protection of the Refugee Convention, or if the applicant put forward information that was found to be untruthful during their application. In our experience, and Fiona may speak to this in more detail, but in our experience, establishing dependency under the old Act was not easy whatsoever. And it would require a lawyer, usually a good lawyer, to assist the applicant in preparing evidence that would show emotional dependency, financial dependency. that showed that dependency has been existing prior to the grant of refugee status and after the grant of refugee status. We would also remind ourselves that these issues have been considered by our courts and indeed by the Supreme Court in the decision of AMS that's referenced in our submission. And there, the court again found that there is a balancing act that the minister has the right to apply in all such cases. He balances the rights of the individual against the power of a state to regulate immigration. And a court, indeed the Supreme Court, will be slow to intervene in that process unless it can be established that that weighing up was unreasonable. What I'm trying to say in all this is to emphasize that this is a modest proposal and the minister still has considerable power to control this process, contrary to perhaps the perception that was developed in the Dáil. I know that the minister has also said that people could also apply to the administrative scheme, but in our submission, and I think Fiona will mention this again in more detail, but that in our experience that is a very arduous and difficult process for an individual to apply through. I'm now going to turn to the money message issue, and what I will say is our perception of what the standing orders say. And to fulfill ourselves in this analysis, we've considered the Oireachtas Libraries and Research Services note on private members' bills, which has been quite helpful. But as Senator Keller has said, as we read it, Standing Order 179 states that a bill cannot be initiated and taken to second stage if it appropriates revenue. We say that this bill doesn't appropriate revenue, it doesn't create a tax, it doesn't create a charge, and indeed, as Senator Keller has suggested, the fact that it has already moved to this point in the legislative process suggests possibly that the Concholar agreed with that analysis. So we are now at the point where we have to consider whether this is an incidental expense. And I note that the standing order doesn't define incidental, and we would ask the committee to be mindful of the following. And that is that on a literal reading of the bill, it does not create any public expenditure, doesn't create a tax, and doesn't necessarily even create an incidental expenditure on a literal reading. If it was enacted tomorrow, it would merely give the opportunity to an individual to apply for the right to family reunification. It wouldn't require the state to create a body to consider those applications, because there is already a body, the Department of Justice, that considers those applications. We also have to be mindful in our submission that incidental must mean something more than simply, for example, the printing of paper and so on. It's not defined, but for the Oireachtas to use the word incidental, it must mean something we would submit more than the consideration of applications which is already processed by the Department of Justice. Even if we continue to have concerns about this issue and within this area of the money message, we'd ask the committee to be mindful of the following: that there is no legal aid for family reunification. In other words, the burden is completely on the applicant to prepare the case. It only creates a right to apply. We are not aware of the department having any reduction in staff necessarily. There is an existing department or part of the Department of Justice that considers these applications. The review body is an internal review on the papers to the Minister, and indeed we would submit that that could arguably reduce costs. If we do think there are costs, it could reduce costs on the ground that it would possibly reduce expensive and long judicial reviews to the High Court. We would also ask the committee to be mindful of the fact that family reunification, in our experience, is a beneficial thing to, indeed, possibly to everybody. And I know that the Minister has made reference to the Family Reunification Directive, which is a European Union instrument, which we've not signed into, but in that instrument, Recital 4, it states that family reunification is a necessary way of making family life possible and helps create socio-cultural stability and promote economic development. As Senator Keller has stated, in our experience, people who come here are often, in the end, net contributors. So, to summarise, we submit that there isn't an appropriation. It doesn't create a tax or a charge. In terms of incidental expenditure, we would submit that it falls below the threshold of what the Oireachtas envisaged by incidental expenditure. And I'd ask the committee to consider the fact that it doesn't create an immediate right. It gives a person the opportunity to apply for the right of family reunification. Those are our submissions around what the bill does and doesn't do, and then the money message and issues around it. And we'd be happy to take any questions.
Thank you, Mr. Henderson. The issue of money messages haunts this committee. And unfortunately, there is nothing we can do about it except protest. But you can be certain that we will continue to do that. So I'd now like to invite Fiona Finn on behalf of NASC to deliver their opening statement, please.
Thank you, Chair. Thank you, everybody, and good morning. Thank you so much for the opportunity to present in front of the committee this morning. Just a little bit about NASC. NASC has over 2 decades of experience in supporting refugees and beneficiaries of international protection with applying for family reunification. So in 2017, we provided 347 consultations in relation to family reunification for refugees, and 43 of our clients who were beneficiaries of international protection were successful in their application to bring family members to Ireland. So our contribution before the committee today is directly informed by the issues that present in our legal clinics and through our direct work with refugees seeking to be reunited with family members. Since the commencement of the International Protection Act in 2015, this happened at the end of 2016, we've seen firsthand the impact that the restrictions on family reunification have had on refugees. In particular, the time limits and the removal of dependent family members, both of which has caused fierce hardship for the refugee families that we work with. People are not fully able to settle into their lives here, knowing that family members remain in conflict zones or are at risk of persecution. We've seen families split up because only some family members are eligible. We have seen individuals descend into deep depression because they are forced to leave family members at home in the midst of horrific conditions. We adamantly believe that this modest but critical amendments to the International Protection Act will go to some significant way to improving the lives of refugees living in Ireland and will help to fulfil our obligations to support people seeking safety in Europe. I would like to take this opportunity to recognise and commend the Minister for State of the Department of Justice and Equality, Deputy David Stanton, for his commitment and dedication to providing solutions for refugees through the Irish Refugee Protection Programme and initiatives such as the Irish Humanitarian Visa Programme and Refugee Community Sponsorship, and also from his statement in the Dáil on the 6th of December, where he confirmed the Government's commitment to assisting families to reunite proactively. So it would seem that we have achieved a kind of a broad consensus here, and our views may not be as divergent as they first appear. Over the course of the debates in the Dáil and the Seanad, the Minister raised a number of concerns, which I would like to address here. Concerns were raised that the current proposals would legally oblige the state to reserve resources for unquantifiable numbers of potential applicants. It must be noted that this bill just provides the right for refugees to apply for some extended family members. This right, as is the case with all rights, it is not absolute and it is not open-ended. It is conditional, and it is highly conditional. It is further limited by the fact that sponsors are required to prove that the subjects of the application are dependent upon him or her, or that they are suffering from a mental or physical disability to such an extent that it is not reasonable for him or her to maintain herself fully. All applicants must provide a very high level of evidence and documentation to support any application. We also know that between 2014 and 2016, under the previous family reunifications provisions in the 1996 Refugee Act, which allowed for extended family members, only between 200 and 400 family members were granted family reunification in any 1 year. Then in 2014, there was only 229 grants. There were 328 in 2015 and 406 in 2016. There's an average of 2.8 family members per group, per sponsor. These are not overwhelming or unmanageable numbers, and they provide us with a very solid base to quantify the numbers of future potential applicants. In our experience, refugee families tend to prioritise their more vulnerable family members, who for the most part are older children, their older unmarried children, or their parents. They also tend to wait until they have secured housing and employment before they submit an application for extended family members, because they want to be ready for the family members when they come. This further illustrates the need for the removal of the 12-month time limit. Since the new Act has come into place, only 272 persons have been approved for family reunification. This is an extremely low number, and one that should cause us some shame, given the extent and reach of the global refugee crisis. We can and we must do more to provide durable solutions for families, and this modest proposal will help undo the harm and suffering that has been caused to refugees. I think we must also be mindful and guided by Article 41.1 of our Constitution, which recognises the family as a primary and fundamental unit group of society and as a moral institution possessing inalienable and imprescriptible rights, antecedent and superior to all positive law, and guarantees its protection by the state. This bill is giving clear effect to both the spirit and the text of our constitutional provision. During the debates, it was noted that the provision would substantially curtail the state's ability to respond to ongoing and future crises. There is nothing in this modest provision that in any way curtails the state to respond to any future or ongoing crisis. This is evidenced by the fact that the government introduced the first humanitarian admissions programme for Syrian refugees during the lifetime of the old Refugee Act, when we had a broader definition of family. We would also submit that by introducing a broader definition of family, it would see a reduction in the need and additional cost of operating ad hoc limited schemes, such as the Irish Humanitarian Admissions Programme. The introduction of broad, clear, rights-based family reunification laws brings with it certainty for both the state and for refugees. The fact that the government had to introduce a humanitarian admissions programme, laudable and all as that was, which afforded a small number of people and Irish nationals the ability to apply for extended family members, it could be viewed as a clear admission by the government that our current family reunification laws are inadequate and in need of reform. During the debates, claims were also made that the Minister for Justice and Equality proactively applies discretionary permissions under the INIS non-EEA policy document on family reunification. Unfortunately, that has not been NASC's experience in supporting families who are applying for visas for their loved ones. I mean, in particular, the Department of Justice in the Department of Justice's own policy, it is stated that the default position for applications for visas for elderly parents is, and I quote, a refusal. So it is difficult to see how such a harsh default position could be construed as a viable alternative for refugees seeking to be reunited with family members. It also requires persons who wish to apply for visas for elderly parents to have an income after taxes and deductions for 3 successive years of €60,000 annually to apply for one parent and €75,000 annually to apply for 2 parents. Realistically, this allows for just the wealthiest in our society to even make an application. Even then, with substantial earnings, applications may still be refused. It is simply unrealistic to expect that a person who is newly granted international protection status will be in a position to anywhere reach those income thresholds. The Minister also noted that the current limited provisions are in line with the EU Family Reunification Directive. I think, firstly, when we're considering the directive, that it's critical to note that, as Nick said, we haven't opted into it, but additionally, this is a unified document and it provides a legal basis for both refugee and non-refugee family reunification, and it sets down minimum standards for Member States to implement. On its face, when we view it in isolation, yes, the current definition of family falls within the minimum standards set out in the directive. However, when we construe the directive as a whole, and in particular when we look at the preamble, which sets out the clear purpose and objective of the directive, it provides and it calls upon Member States to pay special attention should be paid to the situation of refugees on account of the reasons which oblige them to flee their country and to prevent them from leading a normal family life here. More favourable conditions should therefore be laid down for the exercise of their right to family reunification. Also, the directive provides more favourable rights for unaccompanied minors, granting them the right to reunify with their legal guardian. It provides Member States with clear guidance on extended family members, stating positively which family members Member States may include. It sets down clear time limits for the processing of applications and grants a right in law for family reunification for non-refugees, all of which are absent in our current refugee laws. So it is therefore somewhat disingenuous to state that Ireland is in compliance with the directive when we have cherry-picked certain limited provisions to justify the removal of rights for refugees to apply to reunite with extended family members. Concerns were also expressed that we could not go beyond EU norms. However, a 2016 report conducted by the European Migration Network on behalf of the European Commission highlighted that the average percentage of permits issued by all Member States for family members was 30%. Ireland came in second last at 7%. We were just ahead of Poland. So it would seem that we still have some way yet to go to even start to bring us in line with EU norms, let alone exceed EU norms. It is overwhelmingly clear in NASC's experience that refugee families rarely fit into nuclear family arrangements, and the precariousness of life in the midst of conflict means that our understanding of what constitutes a family cannot be rigid or prescribed. In our work, we have come across any number of refugees who are now forced to make real-life Sophie's Choice type decisions when applying for family reunification. One woman had to decide whether to apply for her husband because he was the sole carer of her elderly and unwell mother, who would not be eligible. One man who had applied for his minor daughter, but he was not eligible to apply for his daughter's child, his grandchild, who was born as a result of rape. We have an aged-out minor who has waited for many years for his application for refugee status to be processed in Ireland, is now ineligible to be reunited with his parents and siblings. These are the real unintended consequences of our current laws. And what becomes clear from working day in, day out with beneficiaries of international protection is there are no norms as to how human lives operate in the context of persecution, war and displacement. And finally, as part of our membership bid for the UN Security Council 2021 to 2019, or 2029, Ireland placed empathy at the core. It's one of the core pillars. And the campaign brochure recalls the great compassion and open doors shown around the world to Irish immigrants fleeing famine as they sought refuge. It then goes on to state that we reflect on that as we work to assist today's refugees. We would ask the committee members here to reflect upon this and the impact on the erosion of that family rights has upon refugees, and how this modest proposal will go in some way to ameliorate the harshness of our current laws. Thank you.
Thank you, Fiona. Appreciate that. And am I right? Did you have something you wish to read into the record, Fiona? Ella?
Yes. Thank you.
All right, Fiona, please take the opportunity.
Thank you. I will read into the record a statement by Izzadeen Al-Kharraja, a Palestinian refugee in Ireland. Izzadeen's situation is representative of those who lost their rights to family reunification when the International Protection Act was commenced. And it is typical of the situation of refugees who we see accessing our services. So, dear members of the Justice Committee, thank you for giving me the opportunity to express my problem. Sorry I'm unable to make it here today in person, but I have work commitments and I'm happy for Fiona Hurley to read my statement. I'm a Palestinian refugee living in Cork with my wife and our 4 children. I'd like to thank Ireland for the protection and safety that my family is enjoying. And I would like to thank the Department of Justice for taking only 11 months to decide that we qualify for protection, after we spent 15 years waiting for the Israeli justice system to recognise our family status, with no answer. When we lodged our protection application in September of 2016, our interview was scheduled to be on the 1st of December 2016. Unfortunately, all interviews were cancelled by then to facilitate the new law and procedures enforcement, and I lost a great opportunity to be reunified with my mother that was possible in the old system. In August of 2017, I had my interview according to the new law after the Office of the Refugee Applications Commissioner became the International Protection Office. In order to keep my statement short, please allow me to identify the issues that I see in the current regulations. Although Palestine has the oldest continuous conflict with one of the largest refugee crises, it's not amongst the 10 countries benefiting from the IHAP. Before obtaining protection in Ireland, I was living in Saudi Arabia, and I was able to visit my mother in Palestine from time to time. Unfortunately, after being protected in Ireland, I am no longer allowed to visit her until I obtain full Irish citizenship. The only option remaining to bring my mother here is by sponsoring her. The financial requirements needed for me to qualify to sponsor my mother is so high and unrealistic, because even if I earn half of the current required amount of €70,000, I would still be able to sponsor her living. The current system sets a fixed figure, regardless of the number of family members to be sponsored, and regardless of the family member's potential healthcare cost. In my case, it's only my mother, and she's not so old that she may cost me so high to take care of. In addition to that, I must prove the above income for 3 years, which adds to the unfair complexity of the regulation. Even if I become desperate of bringing my mother to live and decide to invite her for a visit, the current system makes it so hard if it's seen that we attempted to apply for family reunification. I have great confidence that justice in Ireland has room to fit Palestinian vulnerable people, and I have a great hope that new laws or amendments which would make it easier for me to be with my mother again. Sincerely, Izzadeen Al-Kharraja.
Thank you, Fiona. So we now turn to the members of the committee, and we have 4 indications. The first of these is Deputy Mick Wallace, please.
Thanks, Caoimhghín, and thanks very much for your presentations. We're probably unlikely to be fighting with you in here, given that we're kind of on the same side, and we'll save our fighting for the government. I have to go for agricultural questions, so don't take it as disrespectful when I leave. But we are very interested in this whole issue, and we've been very much involved in it. And both myself and Clare Daly, we went to the camps in France, and we've been to Syria twice. We've been to Iraq, Lebanon. Just to start, I just want to make a couple of points. I don't want to bore you. And we came here to listen to you, and it's very good to hear what you have to say. And we'll take that on board and use it to the best of our ability to make things more fair. Nick, you talked a lot about the money message, and you're kind of going through the technical nature of it and what's right, what isn't. The truth of the matter is that they can do whatever they like, right? They can twist that money message around. They can make almost any decision. They can decide to apply the money message rule just about every time if they feel like it. And as Frances beside me will know, her bill, the Occupied Territories bill that went through lately, I mean, they even used that. They used that in the very first minute of their submission in the Dáil against the bill, which is just total nonsense. So really, I suppose our challenge is not to decipher and break down the money message. We have to break down their attitude, and we have to change their mind about how they see things. And yes, some good things have happened, and we're very grateful that they have. The Department of Justice have made some good decisions, and that's good. But it's important to remember that they have been dragged kicking and screaming to this point. If you think back, if you've watched what's gone on in here over the last few years, and the 4,000 number is so small and it hasn't even been reached, and the obstacles to family reunification, we agree with you that they are unreasonable and they don't stack up. I know a lot of the refugees for different reasons, and I mean, I know a guy very well from Afghanistan, and he's looking for family reunification. He's probably not going to qualify. When he was 14, he saw his father was working for the Taliban, and his father was shot in front of him. And a couple of weeks later, he was shot by the Americans. A couple of weeks later, the Taliban came for him. He was 14, and they took him. They kidnapped him and brought him to the camp for training. So he escaped, and he actually made his way to Ireland without money and landed in Dublin, even though he didn't even know that Ireland existed. It's just the way the lorries went. And his mother is alive, and he has a 13-year-old brother and a 15-year-old brother, and the Taliban are looking for the brothers, and they're in hiding. The notion that that we shouldn't help them would be hard to defend. We know another kid from Afghanistan, and his father was actually working for the Americans, and he got shot by the Taliban in front of him as well. And he left a mother and 2 daughters behind him, and he has had no contact with them since, and it's a couple of years now. So he'd obviously like family reunification, but it's not even possible for him to contact them at the moment. And they haven't been able to contact him. And he's 18 now. Both these kids are 18 at the moment. So we agreed that there has to be a different attitude, and obviously some points probably may have an impact on the government. I mean, the issue about, for example, considering that the case law of the European Court of Human Rights holds that the rights to family life, Article 8, extends beyond the nuclear family to include grandparents, uncles, aunts, nieces and nephews, and between adult siblings, there's an argument for expanding the definition of eligible family members even further, perhaps along the lines of the IHAP eligibility requirements, so that for those over 18, they would not necessarily prove dependency. But these are arguments that we can make, and you have made them, and that's good. But it's kind of we're aware of the fact that the International Protection Act 2015 was a serious rollback on the provisions of the 96 Refugee Act, which allowed at the discretion of the Minister for any dependent to be eligible, any grandparent, parent, brother, sister, child, grandchild, ward or guardian of the refugee who is dependent on the refugee or is suffering from a mental or physical disability to an extent that's not reasonable for him or her to maintain himself or herself fully. So, I mean, there's a lot of good reasons for us taking a different position, and for the government to actually be more accommodating for Colette's bill. And next point about most of the people coming here, I think a few of you have made it about, Fiona made it as well, about being the amount of net contributors, the people that come here. I mean, that is so obvious. And all the kids that I've met and the parents that some of the parents that have come here, I mean, God help us and save us. They're going to contribute so much to this country. It's a no-brainer. At the height of when my building company, before it went bang, I was employing 85 East Europeans, and there was a lot of racism in the city at the time. And but I can tell you, they were amazing, and they had such a good attitude. They were the notion that that they wouldn't be welcomed here isn't total nonsense, obviously. But I mean, there's no point. I'm speaking to the converted, saying that to ye. So it's a bit like the priest giving out to the people not coming to mass when they're to the people that are at mass. But look at. We will work hard from our end to try and make it happen, and to when Clare was critical of your bill, Colette, for not going far enough, that wasn't the criticism of you, because we know that if you ask for too much, sometimes you get nothing, right? And we know that we have to be very measured in what we look for. We know it should be an awful lot more we should be asking for, but we'll take the bits at a time. And well done. Thanks very much.
Thank you, Deputy Wallace. I couldn't find a question there at all, so there we are. And to the co-sponsor, Senator Frances Black.
I mean, all I can say is, wow, amazing presentations, absolutely fantastic presentations. And Colette, I know how hard you've worked on this, and also Ben, you know, both of you have put your hearts and souls into this, and I want to thank you for that. You've made the case for this bill very clear, and listening to the presentations, even though you know that it's going on, but it's when you hear the reality of the situation, it's still quite shocking. Do you know? I mean, there's a humanitarian crisis going on, we know, and when you think of what people are going through, the traumas that people are going through, and then to think, when you think about the family, and of course that's an area that I would be very familiar with in my other work, but I also, I'm a family member, and I know how important my family are, and how my adult children are, and how my mother's passed away, but my sisters, my brothers, we're so close, and it's the heart of everything. Family is the heart of everything. It's just so important. And I could go on, but I will try and keep it short. There's a couple of areas. I have two specific questions that I want to ask. And in your presentation, Colette, you mentioned what you said was you noted how it was important that discretion was retained in the bill. And I understand that part of the government's opposition to the bill is based on the idea that it would bring in an open-ended structure for family reunification. So I just wanted to ask you, would you expand a bit on why discretion has been retained in the bill, and how this meets the Minister's concerns? That's the first question. And secondly, the money message. I have to highlight this. money message, because, as you know, Mick said, and it was lovely listening to Mick there, you know, talking about his own experiences with meeting people that really touched his heart. But the money message, and Noel, you really were very clear on it, and I want to thank you for that. It illustrates a very worrying anti-democratic precedent that could be set here today, the money message. As you say, the bill does not appropriate public funds, it does not compel the government to make expenditure, it does not set up a new government agency or create a new body, it also does not give an automatic right to reunification, it simply enables more people to apply. That's what this bill does, that's all it does. It's not rocket science, it's modest, very modest. But essentially it means that department officials may have more applications on their desk to process. Would I be right in saying that? The idea that this extra administration burden is enough to require a money message, I believe, is absolutely ridiculous. I mean, it's crazy. I mean, the standing orders have always been read with a sense of elastic public service, so that a new responsibility or duty doesn't necessarily mean the budget must rise or fall. Under this new reading of the rules, where an administrative cost alone is enough, the Bills Office would be handling the government and an effective veto on any bill. So my concern is that the money message is being constantly brought in to block legislation all of the time. It's constantly being brought in. And it's very frustrating. I mean, why would you want to even start bringing in legislation if it's going to be, from an opposition point of view, where it's going to be constantly blocked? And obviously I'm very passionate about this, because my own bill, you know, has just went through the Dáil there a couple of weeks ago. So I'd like you I'd like as many of you to expand on this as much as is possible, because I'm sure ye are very frustrated. And I'm sure there's a lot of people here in the Oireachtas houses that are very frustrated around this money message. And I think, you know, we just have to highlight it more and talk about it more, because as far as I'm concerned, it's highly undemocratic. So, thank you.
Thank you, Senator. I'll start with you, Senator Colette, and we'll take it up for anyone who would wish to come in after what Colette will say. Thank you.
Thank you very much, Senator Francis. First of all, the discretionary point. What the bill does propose is that you have a right to apply for the extended definition of families as per the old Refugee Act. So in that sense, there is a little bit less discretion for the Minister, but it does not preclude the Department or the Minister to introduce all manner of additional schemes in response to perhaps unfolding crises. For example, I would say that there's a strong case for us to be acting in relation to Yemen at the moment, which doesn't fall into the category of the 10 countries because of the scale of the catastrophe, and I would welcome the Department to do that. But the bill, as we propose it, it does not preclude the Department from doing any of that, and in the debates it was suggested that it might, and I would challenge that. So that's where the bill is. Discretion and rights are not either-ors, they're both ands. And I think that the line of argument that was put forward in the Shannon and Dáil debates are just, they don't hold up in relation to the ability of the Department to act. With regards to the money message, as you rightly said, the bill does not appropriate public funds, it does not compel the government to make expenditure, it does not set up a new government agency or create a new body. Again, really worried about, you know, the constant use of phrases like open-ended and open the floodgates. Really worrying language. This is the language that's always used in relation to migration, and I'm really concerned about those. And I think it's incumbent upon us as members of the Oireachtas to challenge that kind of argumentation and that language. And it is a fundamental misunderstanding of the legislation. And as all of us have said, the bill does not give people an automatic entitlement to bring their dependent family members. It gives them a right to apply. Simply that. So any cost related to this bill would clearly be incidental. And should this bill require a money message, it is difficult, as we've all said, to think of a piece of legislation that would not. And I note what you've said about the elastic public service, and perhaps some of my colleagues may wish to kind of respond and expand to that and the other matters.
Nick, would you like to pick up that?
I'll perhaps take the money message point, and Fiona could speak to the discretion point.
Okay, no, I think let's just go with discretion.
Yeah.
Fiona, if you could.
I'll let you speak of the money message.
I think just a small point on the money message point. So, if we look at the, if we are really going to kind of forensically look at the cost, or is there an additional cost element? So, if you look at the current, the IHAP, the current Irish Humanitarian Admissions Programme, okay, in the first round alone of that programme, there were 908 applications were received. There has never been that scale and number received in a normal yearly family reunification application process, even under the 1996 bill. So we're saying, so there is no, I cannot see where the additional cost is coming. So if there are enough resources to deal with 908 applications, which is an extraordinarily high number of applications, then I can't see why, the numbers that we're looking at under family reunification are in the kind of, the 3 or the 400s, which is significantly less than that.
Yeah, I would really repeat or clarify what I said in that it creates a right. There are likely to be applications, the number of which we can project, but that number of application turns on the number of refugees recognised by the state, and we can project that as well. There is an existing infrastructure, as Fiona has just mentioned, within the Department of Justice that considers these applications. It's currently considering applications made under the 2 IHAP schemes, first in June, second that will close on Friday. The burden is on the applicant. There is no legal aid for the applicant. The state has no expense there. There's a clear test to be met, and the test is laid out explicitly in the bill, who is dependent on the qualified person or is suffering from mental or physical disability. The burden is on the applicant to show that they are dependent on the person or that there is a mental physical disability to such extent that it is not reasonable for him or her to maintain himself or herself fully. That test would have to be met. And then to conclude, and this could require a whole hearing in itself, I suppose, but the long-term benefits both to the individual of family reunification, and it's often said that the final part of a refugee's integration into a country and protection against the persecution that they fear is family reunification. It's that piece that allows the person to finally and properly settle for a period of time in the country that is giving them protection. That's what we would say. I understand Deputy Wallace's point, and I understand your point around the wider use of the money message in the Dáil. But even with that in mind, when we look at the standing order and we look at the guidance given by in the Oireachtas library note, we would maintain that it's not appropriate for a money message to be given. There is no ground, there's no tax created, and then in addition, we would even argue that the incidental cost is questionable, particularly if you take a literal reading of the bill.
I would just add, if I could, on the money message, it comes down to the standing order, that's Standing Order 179, which is based on Article 17.2, and I think in some ways the purpose behind the money message gets lost in these discussions. The purpose of it is to prevent legislators from bringing any kind of financial bills in which would have, huge implications financially for the state. That's a power which is supposed to rest with the executive. But here what we're seeing is the concept of incidental being kind of used to cover cover essentially any policy change which would happen, because it's hard to see how any policy change that you bring in an amendment wouldn't result in some kind of cost, even if it's just printing out the law or retraining staff in the department or whatever else. So I think at this point, and our argument would be that the money message has been kind of bent out of shape and been misapplied to effectively block legislators from being able to bring any kind of amendment like this. And in this particular case, we think it's a good example of how it's being used too broadly, because for us, the only incidental expense which we can see is minor. It's more applications on the desk of a departmental official. And I think it's important to kind of consider it in that sense, because if that's the case, then a money message may not even be required. And that kind of means that the government doesn't have a say in whether or not a money message is given.
And I think before coming back to the Senator, it would be reasonable to say to Frances and to Colette and to our guests that this committee, only last week as a select committee, took a very strong, but in my view, justifiable stance against the practice of denying members the opportunity to make a worthwhile contribution that was clearly in the interest of those who should be the net beneficiaries of the legislation we were discussing. So we very much as a committee have echoed all of that. Frances, please.
In there, sorry.
Add a little about dependency as well, and just echo everything that Colette mentioned. Before this, I had a look through our family unification files, and with regards to the applications that we would have made and been successful on around dependency historically, the amount of evidence that we would have provided would have been staggering, oftentimes encompassing hundreds of money transfer receipts dating back for years, people saving up their at then €19.10 every week from the direct provision centre to send to their family members. Medical reports, the level of evidence was really staggeringly high in a lot of cases. And having had a look through those files, the majority of applications are for nuclear family members, but oftentimes there is one person living in that family unit who is not a nuclear family member, whether that is a brother or sister who's also under 18, whether that is a parent. And the new legislation means that they get left behind. So you lose the person who is oftentimes responsible for bringing up the children left behind. And I think that's something that really needs to be considered, that it's actually breaking up families and not reuniting families. Thank you.
Thank you, Fiona. And back to you, Senator.
Rosemary, I just want to come back to you again around the money message. So when it comes to this piece of legislation, are they saying, are you aware that it's around, the money message is around incidental costs? And would that, I mean, around, is that okay to, sorry, and around that, would that mean like printing a few pages? I mean, can that be used as, you know, introducing a money message to block this bill because it's just for printing, or it's for, I mean, is it to that detail is what I'm asking, or would you be aware of that?
So it's our understanding, and we should probably say it's only our understanding, but it's our understanding that the fact that the bill has come this far means that essentially it's taken for granted that it isn't an appropriation or a public expenditure in that sense, which leaves the question mark over whether or not there's an incidental expense, because the Standing Order 179 also says including incidental expenses, which incidentally isn't the words in in Article 17.2, and I think that's actually an interesting point to consider. But under Standing Order 179, it does include incidental expenses, but the Standing Order doesn't expand on that and doesn't explain what the term incidental could be. So taking one view, it could be absolutely anything. It could be the fact that you take on an extra member of staff. It could be the fact that you're setting up a large agency to oversee a new point of law. Nothing in this bill suggests doing that. What we see is a minor and, again, modest increase in the number of applications. And I think it's the point you made around the elasticity of public service, that kind of thing is usually subsumed into the work of the department anyway. The department won't be getting an additional amount of money to cover it, and that if that were to happen, it would be later on in a future budget. And again, that would be the preserve of the government. So in that sense, I think the incidental expense that we could see happening is really quite minor, and we couldn't even quantify it because we're not the state, so we don't know what that would be, but we can imagine that it would be minor.
Okay, thank you, Senator. And before I bring in our next speaker, two things I want to share with the meeting. I am advised that a determination has been made yesterday that a money message is required and that an application has been sent by the Ceann Comhairle seeking a money message to Isia. So it's just to share that with you. We understand that happened yesterday. And the final thing before I introduce Deputy Jack Chambers is that Senator Martin Conway received a notification that he was required in the Seanad, and he asked that I would record to the meeting his apologies that he had to leave, and secondly, his support for the passage of the bill. He wanted that on the record. So we welcome that as a government senator. That's very welcome indeed. Deputy Jack Chambers, please.
Thanks, Chair. And I'm going to be brief. You gave very comprehensive presentation, everybody. Senator Kelleher and Senator Black, and also the guests, and your expertise is welcome. And I personally support this. I think we should. I know as Deputy Daly may have wanted to go further, but whatever mechanism to narrow discretion and to try and provide an impetus and hope for people is very important. So just go back to the money message. What I suggest is I think there is an issue here across lots of legislation. So I think maybe Senator Kelleher, I think somebody needs to take a stand against the decision-making process perhaps within the Bill's office in the interpretation of this under the Article 17, and I think perhaps get legal advice and challenge it, because I think there is an issue here that is, we're seeing a thread where an incidental administrative cost, it's been interpreted to a ridiculous degree beyond standing orders, beyond the constitutional article, and it's just outrageous. And as Deputy Ó Caoláin mentioned last week, we, the Chair, and I agreed with him, he allowed an amendment to be introduced which was agreeable and wouldn't have had enormous levels of expense, but was important for the disability miscellaneous bill. So I think it's important maybe if external legal advice was sought and if that was formalised and challenged, we could have this addressed, because when there was majority governments, they could just block it because of their majority. Now it's being blocked because of the standing orders within the House, and I think there is a kind of I've concerned with the whole pre-legislative scrutiny changes, and I'm not talking specifically about the bill, but it relates to it and its progression. We've kind of created another layer of pre-legislative scrutiny and address, despite us all agreeing with it. You're going to face the barrier and the roadblock that so many other bills have faced. And the new mechanism means the bill collapses, I think, if the government doesn't agree to a money message within a short period of time. So it vanishes from the legislative programme and it's gone, despite you advancing it as far as you have. So the new business changes that the Business Committee agreed will mean this bill goes off the order paper, it's gone, and it would have to be reintroduced from the get-go, I think. Is that right?
Understanding.
Yeah, which I have difficulties with myself as well, and I think but I think perhaps now is the time to challenge the legal basis for this, because there's issues with the memorandum of understanding, and then there's issues with the interpretation and the agreed interpretation between the government and the Oireachtas via the Ceann Comhairle that I think needs to be addressed. So, look, I wish you well in the bill. I support it, and it's just unfortunate that we're talking about a technical issue that shouldn't be involved here. But it actually shows the nonsense of new politics, because the new politics is actually what's blocking this. It's anything but new. It's old politics of circumventing old interpretation of a constitutional article, which is outrageous and undermines people's ability to get something like this through. So it flies in the face of all the rubbish we've heard about new politics, and I think it's the worst levels of it, actually. It's outrageous. So, look, I have nothing else to add apart from, again, my own disgust at what we're seeing around a piece of legislation. I mean, we regularly hear from the government about how we're all accused of not agreeing with certain amendments to certain piece of legislation. But here we have, the government technically locking out genuine bills, which aren't within the remit of the constitutional article. So maybe it requires a challenge.
That, and I don't think I need to feel that contribution either. So I think we're all on board. Well done, Jack. Caoimhghín. Donncha, you have... Oh, I beg your pardon. Were you showing, Colette? Were you? Did you wish to respond?
I suppose I'm just really, to both Deputy Chamber and the information that you shared with it, it is so disappointing that the government has made up its mind. I mean, we got notification in October 2017. We moved the bill in July 2017 about the money message. So none of our arguments that we made, none of the case that we made were listened to. I mean, that in itself is undemocratic. There has been huge majorities in the Senate and in the Dáil in support of this bill. It is a modest proposal, and it really doesn't fit within the measures that cover money matters. And I go back to the scale of the catastrophe. We're talking technicalities with people's lives in trouble. When we don't do enough in our country, we put burdens on other countries, like the Greek islands, like places in Italy. We see horrific situations when we travel. I saw a little boy in a doorway in Paris 2 Sundays ago. He was about 7 years old with another child, possibly his brother. You could give out about France because they're not doing enough. But when we don't do enough, we also are complicit in the dereliction of our duties as a country in Ireland, but also as part of the solidarity that is there through the EU to act for people in the most desperate of circumstances. So I am disappointed beyond belief, and I certainly will look to the advice that you've given us, Deputy Chambers, to see perhaps we might make a challenge to this ruling. I am deeply disappointed, not just for me and the work that's been put in, but for the people that we are letting down through this technicality, and the fact that none of the arguments that we've made have been listened to, and not even dignified by coming here today and to wait until even tomorrow to make the decision. It's really, really disappointing, not just to me, but to the people like Izzadeen and like all of the others, and the people all over Europe to whom we and all over the world that we have a moral responsibility to respond to. Really, really disappointed.
Can I just ask you something?
You can, of course.
So does it not work that the Bills Office have a look at this debate today, or this discussion today, and then make the decision about the money message? I'm just surprised that the money message has been allocated before this committee meeting. So
it hasn't been allocated. A decision has been made.
Yeah, well, that's what I mean. The decision has been made before anybody even watched this discussion.
Committee stage.
Is that normal?
We can confirm that what I've said is the case, Damien.
Yeah, a decision has been made.
Well, the government could change its mind based on the deliberations that have taken place here today. But the information I've given you is the factual position as I'm advised this morning.
The government will always impose its position as linking it to a money message. The issue is with the interpretation of the standing order by the Bills Office, where their interpretation of the standing order and of the Constitution, like, the government will always try and avoid advancing or progressing of opposition bills, and we know that through the last 3 years. The issue is the interpretation of the Bills Office.
So the Bills Office is listening.
Let me just expand a little bit on what I had shared with you earlier, and Deputy Chambers added his confirmation. Last week we dealt with the Disability Miscellaneous Provisions Bill 2016 in select committee address, committee stage, and the chair is given a direction to disallow certain amendments tabled by opposition members, where in the opinion of the Bills Office, the passage of those amendments could constitute an additional charge on the Exchequer. Now remember what the bill was about, Disability Miscellaneous Provisions Bill. The first amendment that I received a direction to refuse to allow debate was to include in the bill a provision that all polling stations would be wheelchair accessible. Now, I heard you using the word about democratic and anti-democratic, but the fundamental of democracy is the right of all citizens to be able to exercise their franchise. And I was being directed to refuse a motion on the basis that if any of the facilities currently employed didn't have wheelchair access, it might mean having to find an alternative that could cost more, or having to actually put in wheelchair ramp at school, hall, whatever facility. Well, the view of this chair is that, you know, the utilisation of a school or any of these other facilities one time in 5 years is not the basis for why it should be wheelchair accessible. It just damn well should be, full stop and end of story. And I could be in a big bucket of hot water over all of this, but that's the position that we took. And I want to thank the members of this committee who stood by me in that judgment last week. So it's only to share with you, you know, at times how absolutely you talk about interpretation, as Jack has just said, how absolutely bizarre it can be. Senator, please.
Piece here, because I'm very confused, because I was told, our office was told, that the Bills Office would be watching the detailed scrutiny before they made a decision. So, I mean, did that not happen? You know, were they not meant to be watching this discussion today before they make a decision? Is that the norm?
I can't shed sufficient light on that to confirm your understanding of it. I can only, again, advise that that's the information I was given this morning.
Determination after second stage, isn't that the position?
I think that that is the case.
Before it can be discussed at committee, they've made their call.
And the government to take on board the views of the committee. So, you know, I just remind us that this isn't committee stage, this is detailed scrutiny. I think it's important to bear that in mind. Okay, Senator, there are lots of questions and lots of doors to be knocked. Deputy Donegal O'Leary, please.
I suppose I thank all the speakers and the proposers of the bill for bringing this forward. I'll touch briefly on the money message. We do want to, I suppose, maybe have some questions on the specific content of the bill as well. I suppose, just on the money message, I think this has been very valuable, because this is a discussion that's been going on, and I mean, you could reference it on the radio or on television or in these institutions, and I think the general public would kind of go, well, what are they on about? This is just a procedural thing, can't they just get on with it? Whereas I think this has been useful in underlining, firstly, the real implications it has for people's lives when valuable pieces of legislation are blocked. But it's also underlined very clearly, and I think those of us who are in here, we're not under any illusion, this is an issue that hasn't arisen before because we've operated with majority governments. Since we're operating with a minority government, they're no longer in the same position that they were to prevent bills that they didn't like getting through. So they found another way, and that's through the non-provision of money messages. Now, it's unfortunate that the Bills Office has taken, decisions in some circumstances that a money message has to be provided when that's probably debatable. A lot of these decisions can be arbitrary enough. It seems to be, although I'm not sure what basis there is for it, there seems to be a higher threshold for the provision of a money message to go to committee stage than there is for a bill to be put forward at second stage. And there seems to be a threshold somewhere in between the two to put forward an amendment that may have some incidental cost. So there's a lack of transparency there, and I think Deputy Chambers is right. Perhaps there is an action that could potentially be taken on the basis of Article 17.2. I suppose it has never arisen before, as I say, because of a clear government majority that exists. So I think it is, everything that's been said, I agree with 100%. It is anti-democratic. It is a minority government foisting its will on the majority through a procedural trick. And it's unfortunate the lack of transparency that exists. So look, I think that has been well ventilated, but I think it's useful. If people want to respond, they can, if they have additional points to offer on that. But I just want, my questions are just going back to the substance of the bill as well. So the first one is, I suppose in relation to, there's a fair bit of, we received a very useful briefing document from the Library and Research Service on this legislation. One of the points identified was there was research done by a gentleman, Caoimhghín there, on the legislation as it was prior to the most recent change under the, I think it was the 96 Refugee Act. And the point that was making is that one of the primary difficulties that existed at that stage was in fact what was described as the nebulous definition of dependency. I think this was a point, perhaps, I don't quite recall, but I think it may have been raised at second stage as well. And I suppose my question is, like, will we see the full benefit of this, or perhaps, and we may, but if there are difficulties with, it may favour the applicant or it may favour the government's current position, but if it's insufficiently clear what a dependent is or what qualifies as dependency, will that potentially hamstring the intent of this debate? Alternatively, it might lead to a more expansive understanding of it. I'm not entirely sure.
Question,
yeah,
is
it
to
speakers, yeah.
Fiona, would you like to?
Just very quickly, and my colleague Fiona might wish to step in. The 1996 Act, Section 18.4, which talks about dependency, it's been in place now for almost a decade, but it's also brought with it quite a strong body of jurisprudence around the issue of dependency. So the courts have looked at it. So whilst, yes, there is an element of discretion kind of inherent in it, but the courts have set down pretty clear guidelines as to what would be considered as dependence. So say, for example, it is not just financial. It is not, there is an element of kind of emotional dependency, and the nature and type of dependency, the fact that dependency has to be continuous and ongoing. So I think the fact that that section of the Act has been in operation for 10 years. I think there's quite a clear understanding of what we mean by dependency, and there's a lot of settled law behind that. So I don't see that would present itself as a particular issue or a barrier.
Okay, would you like to, please? No, Fiona, Ella, if you'd like to come in.
On a very practical level, I think an issue was, and Nick raised this earlier, is that there's no legal aid for family reunification applications. So a refugee themselves may not know what the definition of dependency is. And that would lead to someone applying without knowing what standard or thresholds they had to meet. if someone has access to a practitioner or someone comes to an organisation like the Refugee Counsellor to NASC, then they can get that advice. One of the issues, and I suppose this is an issue very widely with the Department of Justice, is that the Department of Justice is very reluctant to put in place detailed policy or detailed information on what they actually are looking for. It's up to the applicant to bring information, and then at that stage a decision is made. So that could go hand in hand with the Department being more transparent about what they would actually consider to be dependency as well, and that would, I think, resolve a lot of the issues and help people to access family unification in a better manner.
Okay. Would you like to, please, Nick?
It's a good question, and I think I'd only add to what Fiona said, which is that there is jurisprudence, and it goes to the most senior court, the Supreme Court in AMS, considers this in detail. So, and I'd suggest that that's the next best thing from dependency actually being spelt out in the bill. We have a body of jurisprudence, including a Supreme Court decision and practice for more than a decade.
Colette, please.
There is case law, as Fiona and Nick have said, and then there is also clarity that makes it easier to understand what the concept of dependency is. And I suppose we go back to, I mean, I've been kind of following the whole disgrace of the way that people from the Windrush generation have been treated in the UK, and the current Prime Minister's sort of desire when she was Home Secretary to create a harsh environment for immigrants and people who would seek to settle in a country. There is how you do things, and you can create through sort of obfuscation or unclarity. You can have the law, but you can make the kind of the access to that law as difficult as possible or as easy as possible. So there's also the spirit of how regulations and laws are kind of put in place and interpreted. And I suppose I'm very disappointed by the way that the department has responded to this bill since it was moved. And the spirit has been defensive. It hasn't given a listening ear to the arguments made. And I think that is the case too on the ground for people who would apply. And I think that's another worrying trend that has been evidenced through the progress of this bill, and I think something that this committee possibly has noted, but perhaps in any report issuing from today might also be reflected upon.
Okay. And just before I come back, would you like to add anything, Rosemary? No? You're okay? I'll come back to you in a moment, Senator. No, Deputy O'Leary still has. Please, Donncha, would you like to pick up on?
I will, unless you're under time.
No, I'm not under.
Just, I suppose, on that, like, look, it's well noted. I mean, you could write the script, any issues relating to migration or asylum. Department of Justice come in, talk about push, pull. You know, Evan and their mother will come to Ireland if we change X, Y, Z, whether it's the right to work, whether it's family reunification. All these very vague allusions are made to pull factors. Now we need to stay away from pull factors and all that kind of stuff. So, look, it's been well noted, and we're more than familiar with the general outline of, I suppose, objections that the Department of Justice gives to fairly any adjustments in this regard. I suppose just, and even on foot of that, like, I mean, would the speakers agree there's I mean, the Department's argument is perhaps somewhat undermined by the fact that if they're saying that it's an unquantifiable number that might potentially be applying for family reunification, surely given the fact that there is a more expansive definition for reunification categories under the IHAP programme, which are the 10 most significant locations of refugees, surely that underlines a clear inconsistency in the Department's position. Would the speakers agree with that?
Anybody like to take lead on this? Fiona.
So one of the issues with the 10 countries that applications were eligible from is that in several of the countries we actually haven't had any applications for asylum they're global statistics and not statistics relating to Ireland. So, for example, Iraq wasn't included on that list, and Iraq would be a country where we receive a relatively high number of applications for asylum and would give grants of refugee status. And in fact, I think Iraq had the highest number of applications from, for IHAP that were refused because they were from an ineligible country. So many Iraqis also applied, and I think gave their circumstances and argued why they should be considered, and they were refused under the IHAP. So, for example, Central African Republic, it's extremely rare that you would meet anyone from Central African Republic in Ireland. There's just very few people. So, with those countries that were picked, they weren't picked with an eye to what was actually happening in Ireland and reflecting the people who actually need family unification in Ireland.
CER is one of the 10.
Yeah.
You wish to come in, Fiona? Yeah.
Thank you, Deputy O'Leary. I think, that it is a clear contradiction, given the fact that they have introduced the IHAP, which is a much more expanded programme. I know it's a limited programme, but it is an expanded programme. So it allows for the extended family members, but it also has an additional category where you can apply for a vulnerable family member, and that family member is not, there's no kind of guidance around that. So on the one hand, you have the state saying, it's uncontrollable floodgates, and on the other hand, you have them delivering two schemes, whilst they're not to be, they're to be welcomed, but they're temporary and they're ad hoc. And I think that tends to be the problem with how policy is developed in the kind of immigration and the protection context. It's very ad hoc, it's very piecemeal. And I think what this bill does, it brings a level of certainty for both the state and for refugees who are looking to be reunited with family members. I think the other point I'd make on the IHAP was one of the key drivers, from our understanding, of introducing the humanitarian admissions programme was to fulfil the 4,000 quota that we had committed to under the EU resettlement and relocation programme. So it was one of the mechanisms used to do that. So it wasn't, I suppose, in a sense, born out of a necessity or a need to support refugees that are living in Ireland. So that was a primary driver for the programme.
Anything else before I go back to the deputy? No, we're okay.
Yeah,
okay.
I suppose I'll ask the remainder of my questions together. I suppose just on that point, I suppose I'm not, the IHAP programme I think is a good programme, but I'm not by any means advocating that it's a solution to all these problems. I suppose what I'm specifically outlining is, it's not consistent with the arguments they're making against this bill when you consider their policies on the IHAP programme. My final two questions, I suppose, firstly, section 57A, I think, of the bill which was added, is it 57? The review piece anyway, I might have the section wrong. The review piece that was added in the Shannon anyway, that amendment, there's a point I suppose that maybe hasn't been discussed as much. So maybe if Colette or any of the other speakers can expand on that, and maybe just on foot of that as well, is there generally a need to review how reviews and appeals in the whole area of asylum immigration are handled? Do we need an overhaul of the legislation and the offices governing that? And then finally, I suppose, I think it's been touched on, would the speakers be of the view that persons applying for family unification should be entitled to legal aid?
He said two, but I picked up on three questions there, so we'll Colette, would you like to lead off, please?
I think in any piece of legislation, a review mechanism is a useful and healthy thing. And for example, in the Education Admissions to School Act, there's a review in sections relating to that in terms of whether the measures are actually achieving their intended consequences. But I think in relation to family reunification, there are perhaps unintended consequences. And I think what drove us to put forward the bill as it stands was the fact that on the ground there are real live issues in relation to access to family reunification arising as a result. And you saw the case of Izzadeen. He missed an appointment. It was cancelled. Had he had that appointment, he might have been able to succeed in bringing his mother to Ireland. But because it was cancelled and it didn't happen until after the International Protection Act, he couldn't. So that's how arbitrary it is, and that's why review mechanisms are so important. And yes, I would say that for the points that Fiona made and Nick have made, legal aid would be important because it may steer people in the right direction and within the parameters of what's possible within the law, rather than people kind of putting in claims that will never succeed.
Nick, yes, please.
I would agree. And let's be clear, I wouldn't describe what is laid out in the bill as an appeal mechanism. For it to be an appeal, we would submit it would be an appeal to the International Protection Appeals Tribunal, which is a statutory body created by the International Protection Act, and that act would probably have to be amended to allow for appeals against a refusal of a family reunification decision. It doesn't do that. All it really is doing is creating an internal review within the Department of Justice, and it goes up the tree, if you like, to a grade senior to the grade of the person that made the decision. So you would only have to be one step more senior than the person who made the decision to consider that review. I suppose it's also consistent with changes that were brought about by this statutory instrument that was created in July of last year that transposed the Reception Conditions Directive into Irish law, and that creates an internal review mechanism for decisions around somebody's reception conditions. So it's similar in nature to that. And then on the final point in legal aid, again, it's beyond the scope of this bill, but we would wholeheartedly agree. In our experience, and I'm sure it's the same with our colleagues in NASC, it is essential that people get good legal advice at all stages of the asylum procedure. If they don't, then they may not ventilate a point that should be made. They may not bring forward evidence that they have. And indeed, it can work inversely. They may be pursuing an application that they shouldn't be. They may have a remedy elsewhere. And it helps them to rehearse and corral the evidence that they have. So I completely agree.
Thank you for that. Yes, Rosemary.
I agree with both what Senator Klatt and what Nick have said, and I would just add that in general, outside of an appeal or review mechanism like this, the default is always judicial review, and that obviously has its problems in terms of clogging up the courts, and it's a real problem in the immigration and asylum area because oftentimes it ends up being judicial review that's the only remedy available to people, and that ends up being expensive and it's delays for everybody involved, and in the absence of legal aid, they can often be not the kind of cases which should be developed, as Nick has said, for the reasons outlined. So I do think these kind of appeal processes are in everybody's interest ultimately.
Okay, are we all right with that? Deputy Leary, thank you very much. And the last word, very appropriately, Senator.
I'm a little bit obsessed with the money message, Caoimhghín, so you'll have to forgive me.
Well, I can't do anything about that today.
Well, I just want to put 2 points on record, if that's okay. In the new Memorandum of Understanding for PMBs agreed at the Dáil Business Committee in December and in place from the start of this month, and I'm going to quote it, it says, "Under this new Memorandum of Understanding, the Bills Office will conduct a preliminary assessment in relation to money messages once the bill has passed second stage. However, the assessment will not be finalised until committee scrutiny is completed, and messages will not be requested from DPER until after the order for committee stage is agreed." Now, the fact that the Bills Office has made that decision in advance on this committee discussion is totally contrary to the procedure in this MOU agreed by all parties at the committee. And the second point I'd like to make here, is the remaining bills awaiting committee stage should undergo committee scrutiny under the terms of this MOU. So it seems to me that by the terms of this MOU, a decision should not have been taken before this discussion, and I would just like to put that on record.
What I'd like to put on the record is that the right decision should always be made, and clearly that's not what's happened in my opinion, and I'm saying so very bluntly and clearly. But I think, and we're going to have to explore, I mean, I welcome what you've just read into the record here this morning, but it is likely to prove to be the fact that this bill was before the MOU was adopted. This bill was in the process and referred. So we will just have to, I'm only offering a possibility. Damien? That's much more specific. The MOU only applies to bills referred after the 20th of January. So we won't be able to use that argument, as I was suggesting. I've just had it confirmed to me by the clerk that the MOU only applies to bills referred after the 20th of January. And as Colette and yourself both know very well, we've had this for some time before. And that is the fig leaf that will be used to justify having proceeded without waiting for our deliberations here today. I think it only highlights and underscores all that we have been saying already. Senator, do you have anything further you'd like to add?
Thank you.
Okay. Well, look, I think that it's fair to say that in all our respective ways, we will endeavour to impact on the view given by the Bill's Office. We need to concentrate on those who have the final say. That's the government. And at least we have one part of that in place today with Senator Conway's declaration of support. We'll have to add to it. So is there anything further, Colette, before we bring this session to a close that you would like to add without going back down that particular road again?
I mean, you know, there is a refugee crisis that is unprecedented. Ireland has to play its part alongside all of the other countries in the world in that part. Family reunification is a critical part, and just because we are blocked here today doesn't mean that the refugee crisis has ended and doesn't end Ireland's moral obligations, so it doesn't go away. It is a shame that this avenue couldn't be pursued, because it would, a small change would make a big difference to a lot of people who've already suffered a great deal. And I am disappointed that we are not lifting that burden for people who've already had such trouble in their lives, unimaginable trouble. I cannot imagine a situation where I would have to choose between a son and a daughter in terms of who I'd want to support. So I don't think you've heard the last of us on this matter, and we will kind of regroup and see what we can do. And I am very disappointed that there has been such resistance to such a modest, humane and decent measure for people who have suffered in a way that we can't even imagine.
Two things in relation to your closing remarks. We haven't been blocked here today. This is the last committee where that would ever happen. We have had the opportunity to fulsomely address the issue. And the second thing I want to add is, when you say you haven't heard the last of us, I want to say, reflecting on the fact that every member of this committee who attended here today have recorded their support. And I think it's a case of we will be heard in every way that we can in going forward in support of the bill. And I want to, on behalf of the Justice and Equality Committee, to commend you, Senator Kelleher, and our colleague, Senator Francis Black, and all your co-sponsors of the bill. I want to thank the Irish Refugee Council and our long-standing friends in NASC for having travelled all the way again. Donncha was just getting homesick. He wanted Cork accents and voices here. And I want to thank Senator Rowan, who has just joined us, and say well done. You have all our support in the bill's progress, and to our visitors. So, without any further ado, on behalf of the committee, I thank each of you for your contributions here today, and to declare that the joint committee is adjourned until 9 a.m. on Wednesday next, the 13th of February. Go raibh míle maith agaibh.